Good afternoon. This is Emily Sumner. If you all can hear me, if you would just type in the chat box that you can hear me, just so I know that you can hear me okay. Is that a yes? Can you guys hear me? It's noon, so we're going to go ahead and get started. Thank you all for coming to our monthly coffee with Sumner Immigration Law. I hope you have a good cup of joe with you. Just as a friendly reminder before we actually dive in, this information is for, or this presentation is for informational purposes only, and it is not designed to be legal advice. We can't give legal advice in this type of venue. We did receive some questions that are really detailed and fact-specific, case-specific, and we're not able to answer those questions. So if you submitted a question that we are not answering during this webinar, then please feel free to send us an email. If you're a current client, we're happy to help you. If you are a prospective client, send us an email and we'll help you set up a consultation so that we can discuss your situation in more detail. So with that, we will go ahead and get started. So USCIS update, and as we go along, if you all have questions, feel free to put those questions in the chat. If you have additional questions that you haven't already submitted, feel free to put those in the chat, and to the extent that we have time, we'll certainly answer those questions. So we've had lots of questions about what's going on with USCIS. As you may know, USCIS has been closed since the beginning of the quarantine, about mid-March or so. My last interview with USCIS was March 13th. So USCIS has been closed and they are set to reopen, or they have reopened as of June 4th. There are going to be some differences, of course, as you would imagine, with USCIS. Certain field offices are opening, so we can't assume that every single field office is opening. We understand that our local office, Norfolk, is opening, but other offices may be staggered across the country. Application support centers, which is where you have the fingerprinting done, they will reopen services later. There are certain health and sanitation precautions in place, and USCIS has detailed information about that should be on the notices that you receive for interviews or fingerprinting. You absolutely have to have a scheduled appointment with USCIS before you arrive there. That was true even before the pandemic. You couldn't just walk in. They used to have emergency InfoPass appointments where you could just walk in, and that's no longer the case. It hasn't been the case in a while. So you definitely have to have a scheduled appointment. USCIS is having a public engagement webinar on June 18th that our office will be attending, and we will post more information, more detailed information once we have that after the webinar with USCIS. So what happens if you had an appointment scheduled with USCIS and it has been postponed because of the pandemic? If that is the case, your office, USCIS field office, your local office should automatically reschedule the appointment and that applies to fingerprinting, to naturalization interviews, naturalization ceremonies, and then any other interviews that were scheduled with USCIS. Keep in mind that USCIS was able to continue working on certain green cards. We've had at least a handful of clients whose employment-based green cards were approved without an interview. So that's great, that it was approved without an interview. So of course, if your green card is already approved, you're not going to have to go to the interview. But family-based cases, marriage-based cases definitely have to have the interview, and those should be automatically rescheduled. You should receive an appointment letter in the mail. If you don't receive an appointment notice within 90 days of your local office reopening, you can, of course, contact us if we're your attorney. We'll be in touch with you on that. And if you are not working with us, if you're doing this on your own or with another attorney, then you can contact USCIS to ask about having the appointment rescheduled. Naturalization ceremonies, oath ceremonies. So this is the swearing in ceremony. Once USCIS has approved your petition, your application for naturalization, they will send notices to applicants to reschedule those postponed naturalization ceremonies. The ceremonies will be different going forward, just like a lot of things in our life will be different going forward after the pandemic. There will be shortened ceremonies. They won't play videos during the naturalization ceremonies, but they'll give a flyer with information, and attendance will be limited just to the person that's going to be naturalized, unless that person has a medical need for a person to assist them, like someone with a disability, for example. But we hope that those naturalization ceremonies will resume in the near future. In the Richmond area, the oath ceremonies were taking about 3 to 4 months to be scheduled from the time the case was approved, the naturalization case was approved. So it could be because, and this applies to other types of interviews as well, because USCIS has been closed and the courts have been closed for the past 2 or 3 months, they are going to have a backlog to work through. So it could, at least for now, take longer than the anticipated time that it did before. When will consulates reopen? We have lots of questions on this every day from clients. That's an excellent question. Right now, we don't have information about consulates reopening. So USCIS has been pretty forthcoming. I said that USCIS is planning to open, or did plan to open, on June 4th, but that applied to certain offices, not necessarily all of them. We haven't gotten any sort of concrete information from consulates yet as to when they are reopening. That's probably because it's a lot trickier of a situation, because the US consulates are located across the world with different situations as far as the pandemic that are occurring across the world, and different precautions being taken in different countries. So as of right now, offices, consulates across the globe are not reopened. They are open only for emergency situations, and they're really focusing on services to US citizens. So if you're waiting to schedule an interview or an appointment at a US consulate, you're probably going to have to wait a good bit longer for that to reopen. We will certainly put information out there once we have information about consulates reopening. Our office does have some, we're seeing that the NVC, the National Visa Center, is not currently scheduling interviews for immigrant visas. We haven't seen that happen in the past several months. We have several K-1 clients, fiance visa clients, who were scheduled for interviews in June, and that's been pushed back to late summer, early fall. So hopefully it will happen then. But keep in mind, we don't know what's going to happen with the pandemic, if there's going to be a second wave, or if consulates will decide they're actually not ready to reopen, and those also could be rescheduled. So what happens if you're stuck in the United States? We've talked to several clients and prospective clients over these past several months who are quote unquote stuck in the United States. That is, they can't get a flight to their home country. They are not able to, and their I-94 is about to end. They're needing to leave the United States sooner rather than later, but they're just not able to leave because of travel restrictions or the unavailability of flights. If you are here on a B1B2, that is a visitor's visa. So B1 is for people who are participating in business activities in the United States. The B2 is a visitor visa for tourism, and it's the same. You get what's called a B1B2 visa, regardless of whether you're coming for tourism or pleasure or for business. So if you're here on a B1B2 and your I-94 is going to end, and you think you might not be able to leave the United States before the I-94 expires, you can ask for an extension of your B1B2 status. This has always been the case, but we are hopeful that USCIS will be especially understanding in this situation where you truly might not be able to because of travel restrictions or because of the availability of flights or other forms of travel. You might not be able to leave the United States before your anticipated date or on your anticipated exit date. So if that happens, you would need to file what's called the Form I-539. That's the form that you would file in order to ask for an extension of your B1B2 status. I would recommend that you, if you're doing this on your own, definitely read the instructions online that are available online to make sure you're filing it properly with the correct filing fees, sending it to the right place. And then I would include documentation of why you're not able to leave on time. Whether that's because, like I said, because of the travel restrictions, or because I hope that nobody is sick, but if you were sick or a family member is sick and you're not able to travel, whatever the reason is, you should include that with your filing. And that's something we're happy to help with if anyone out there needs help with filing an extension of their visitor status. If a person is in the United States on ESTA, which is it's similar to a B1B2, but it's the program that a person would come in to enter the United States on if they are from an ESTA country. So a lot of the European countries and certain other countries allow for ESTA, meaning you have 90 days to be in the United States. So if you're on ESTA, you can request something called satisfactory departure. You would request that either from USCIS by calling the 1-800 number, or from the local CBP authority port, the port of entry. There's specific processes to do that. So if you are in a situation where you're here on ESTA and you're not able to leave on time and you need to extend your stay, be sure to contact us if you need assistance with that, or there's also information available online, but we're happy to help if you need information or help with filing for the satisfactory departure. It's similar to the B1B2 extension. It's just applicable to people who are in the United States on ESTA. If you're here on another visa classification and you're planning to leave, it depends on your options, depend on what visa classification you're in. So for example, if you are here on an H1B and you have decided not to continue, not to stay here, or if unfortunately your job has ended and you need to leave the United States, there may be options for that as well. There are options for that as well. It depends on your situation. With the H1B, there's a 60-day grace period, 60 days or until your I-94 ends. If you're not able to take advantage of that, you may be able to file a change of status to B1B2. A similar situation for an F1 student. If you're here in the United States studying and you plan to return home, but you can't because of the virus, you have a grace period typically at the end of your studies that you could use, or alternatively, you may be able to file for a change of status to B1B2. So just keep in mind that regardless of what your immigration status is in the United States, it is possible to extend your stay if you need to because of the pandemic, but your options depend on your current visa classification and your specific facts. So if you have questions, specific questions about that, please don't hesitate to reach out to us and we're happy to help. We had several questions about applying for a marriage-based green card. The marriage-based green card, so the questions that we received, I believe, I don't know for sure, but I believe are from people who were in the United States visiting and then changed their mind when they were here in the United States and decided, okay, maybe I will get married. Or maybe that was the plan all along. Maybe they were here on a student visa or H1B and they're interested in applying for a green card here in the United States. That is definitely possible. Again, fact specific, so I can't give specific legal advice on this particular forum or through this webinar, but in general, the process is you have to be married. It does not have to be a fancy wedding. You just have to be legally married. You and your spouse would file a package of forms. And I'm not telling you all of the forms that are available because it's a lot of them. It's before the I-944, it was about 81 pages worth of forms. And now with the I-944, that added another 18 pages. So roughly 100 pages worth of forms that you need to complete and submit to USCIS. So I definitely recommend that you talk to an immigration attorney if you're thinking of filing for this, but generally speaking, your spouse, the US citizen spouse, would file the I-130 petition saying, I'm a US citizen, I want to sponsor my spouse to be a permanent resident in the United States. And then the foreign national would also at the same time file the I-45, the application for permanent residence in the United States. At the same time, the foreign national can apply for a work permit and a travel document that would allow that person to work and travel in the United States. As far as processing times go, we've had lots of questions from prospective clients and current clients about the timelines for a marriage-based case. Before the pandemic, we would say it would take roughly 6 to 9 months, maybe closer to 9 to 12, depending on where in the United States you are applying for the green card. It depends in part on the local office, their processing times. So in the Richmond area, it was taking 6 to 9 months before the pandemic. USCIS was still working during the pandemic. They were able to telework. They had that in place anyway before the pandemic, which was great. So they were able to work, but they were not able to conduct fingerprinting, and they were not able to conduct the in-person interviews that are required for marriage-based cases. So because they weren't able to do that, there is going to be a bit of a backlog. USCIS has to approve the fingerprints, or rather they have to process the fingerprints for the work permit and travel document to be approved. So before, we were saying from the time you file to the time you get the work permit and travel document might be about 6 to 9 months. It might be a little bit longer. That was pre-pandemic. Now we're saying, well, they're still working. They have still been working, but we don't know exactly how long it will take them to work through that backlog. So if I were advising a client now, I would say it's probably going to be closer, possibly closer to the 9-month mark before you get that work permit and travel document. If you are in another status like F1 and you're working on OPT, or if you're an H1B, you can use the work permit that you have or the work authorization that you have to keep working in the meantime. But the point is, the bottom line is, we don't know exactly how processing times are going to be impacted because we've never lived through a pandemic before. We've never had this exact type of situation before. So we don't know how quickly USCIS is going to be able to work through the backlog. Hopefully it won't take too long, and before long, within a few months, they'll be back on track with the same time frame, or maybe better, probably not, that they had before. But we just don't know at this point. And we'll certainly post updates and keep people apprised as to how long they're taking once we have that information. But right now, we just don't know. So again, timelines, probably a bit longer than 6 to 9 months from the time you file to the time you get your EAD and work permit, and then probably at least a month or two beyond that for the interview. Before the pandemic, we were seeing that clients would receive the green card usually within a couple of weeks after the interview. USCIS always said that we had to file or we had to wait at least 120 days after the interview before following up. But typically, and I would say 99% of the cases, the clients receive the green card within a week or two. When to file the marriage-based green card, that is pretty fact specific. It depends on your specific situation, but I will say that there's no waiting period. So if you get married, we have had clients before who come in and say, we're interested in filing this. We're planning on getting married, let's just say July 1st. I'm just making this up. And we would go ahead and get everything ready so that as soon as they have that marriage certificate in hand the marriage certificate in hand after their wedding, we're able to just slip that in and file. So there's no waiting time, no specific amount of time after you're married that you have to file. And then we talked about how timelines are impacted by COVID. H1B updates, we had several questions about H1Bs. The H1B premium processing for H1Bs and for I-140 petitions, which is part of the employment-based green card, premium processing is being phased in the month of June. So if the case I'm talking about H1Bs right now, if an H1B case was previously filed, if it was filed before June 8th, then at this time you can file what's called a premium processing upgrade, which is when you submit the I-907 form, the form that's required for premium processing, and the check. The check amount is $1,440 that you would need for premium processing. So you can go ahead and submit that, and then your case should be converted, your petition should be converted to premium processing. As of June 15th, this coming Monday, CAP exempt petitions, that means petitions, I'm talking about CAP exempt employers. So universities or certain nonprofits that have affiliations with universities or institutions of higher education can file at that time. And then June 22nd, everybody, CAP subject and any other H1B petition can file or H1B petitioner can file the premium processing request at that time. Immigration attorneys have found this confusing, and we do this every day, all day, sometimes at night as well. So if you're confused about this, just let us know and we're happy to clarify. We also received several questions about working from home. That's still very much going on. Our office is still working remotely and we will indefinitely. So working from home is still a big concern. With H1B workers in general, on the H1B petition, the employer has to indicate where the H1B worker will be working. So that's either going to be at the employer's office, or sometimes they work from home always, which is fine, or it's going to be what's called an end client site. So if you are on H1B and you're working from home, then there's several questions that you have to ask yourself to see if you're in compliance, or that the employer has to ask. One is, and this is just a very high level overview, so email with questions if you have them. But the first question is, are you still working within the same MSA, Metropolitan Statistical Area, or within commuting distance of the address that's listed on the I-129? If you are, then that's great. You can work from home. You actually need to post the notice of filing or the LCA at your new work site, which is your home. So yes, post the LCA or the notice of filing on your fridge and in front of your TV. I know that's ridiculous, but that's how you comply with the regulations. If you are, so that's if you're working within the same geographical area as the address that was listed on your I-129. If you are not, if you're, let's say that your work site was listed to be in New York and you're living in California because that's where your permanent home is, or for whatever reason, you're working in a different state or far away, then you can work remotely for up to 30 days. There's an exception for 60 days, but I don't like to rely on that. It gets complicated. But I would say if you're working away from the office, working from home for more than 30 days, and you're not within the geographical area of your work site, then you need to have a conversation with your employer about filing an amended petition to make sure that you're in compliance. And again, that's a complicated and very fact-specific situation, so feel free to email us if you have specific questions. H1B transfers are still processing as normal. We're actually seeing, and I don't have a clear explanation for this, but we're seeing the H1B petitions are often being approved in 1 to 2 months. That's much faster than they were before the pandemic. I don't know if that's because officers are working on H1B petitions from home instead of doing interviews. I don't know what the situation is, but I won't complain, that's great. That does not mean that every single petition is being adjudicated in that time frame. Certainly we have ones that are taking longer, and so there's no guarantee at all. But we're seeing the H1B transfers, amendments, extensions are being, in general, being processed within the same time frames as originally, before the pandemic, or even faster. Keep in mind with premium processing, as I said before, if you need to upgrade to premium processing or file and request premium processing, that is an option now. We had a question about the Healthcare Workforce Resilience Act. We have some detailed information about that I'm not going to read to you, but just know, you can look at the information here. Just know that this is an act that is in Congress. It's being debated. It has not gone anywhere. I have practiced for 15 years now, and lots of bills have come up that we as immigration attorneys have been very excited about, that would really benefit our clients. And some of them have passed, but very few don't. The majority of bills that are up there, up being debated, just don't make it out of committee or aren't passed by both houses, whatever the situation might be. So I'm hopeful that this will pass, but I'm not holding my breath. It's very possible that nothing will actually come of this. And I don't mean to be a downer there, but just being realistic, I've seen so many proposed statutes and similar legislation before that just hasn't come to fruition. So we'll see what happens with this. But right now, it's not moving forward. Let's see what additional questions we have. And while we're looking at any additional questions, feel free to put any, we have about 5 minutes left. 6 minutes left. So if you have questions, we have a couple that have come in, but if you have other questions, feel free to put those in the chat box. In the meantime, ways that you can stay connected with us and stay updated are reading our blog posts. We post regularly on our blog, which is on our website, sumnerimmigration.com. Join our newsletter. We send a newsletter at the first of every month. And you can sign up for our newsletter if you want to, going to our homepage, which is, again, sumnerimmigration.com. And there's a box at the bottom right where you can enter your information to subscribe to our newsletter. We do not share your information, and you can always unsubscribe if you want to. And then RSVP to future webinars. We started doing these webinars. We've done a few previously, but during the pandemic, during quarantine, we've done more and more. And we find it's a great way to connect with people and get information out to people, which we're happy to do. We want to be here to help you and support you. So we plan to do these once a month on the second Wednesdays of the month. I think it'll be a week later in July because of the Independence Day holiday, but that will be in our July newsletter. Going to some other questions now. We have a question about public benefit and public charge. Does it affect H1B prospective employees? Yes, we do. The public charge does, in theory, affect them. There are questions on the I-129, which is the form that we use to submit H1B petitions. And those questions on the I-129 ask if you've ever applied for or received certain public benefits. So that's a question we're asking all of our H1B employees, all of our H1B clients now, to make sure that they have not applied and have not received any public benefits. It's not as, the public charge issue is not as intense or extensive for H1Bs as it is for other people, like people applying for the green card. If you're applying for a green card, for example, submitting the affidavit of support, submitting the I-485 application for permanent residence, then it really depends on, most of the people submitting that type of form do have to submit the I-944, which is the 18-page form where they ask for all of your debts, your income, household income. They ask for a credit report. They ask for documentation that you speak English, documentation of your education. So yes, that is a concern for people applying for a green card, but it's not, you don't have to give all of that information if you are just applying for an H. And really, if you're applying for an H, you would not qualify for those public benefits anyway, so it shouldn't be an issue. It's an additional question that we have to answer, and it's added a page to the form, but generally it's not a huge issue for H-1B employees. Another question is, there's been rumor, and I think this is the last question that we'll be able to take today, but there's been rumor about some sort of executive order coming next week that will affect HL visas. Is there any validity to this, or is it just a rumor? I don't have concrete information. What I'm going to say right now is it's just a rumor. So you may remember that with the presidential proclamation that Trump gave in April, part of that proclamation said he directed agencies like USCIS to, quote unquote, look at other non-immigrant visa programs like the H1B program and other similar programs, perhaps the L program. So he's directed those agencies to look at those programs. The wording was pretty vague. And he asked if the agencies look and report back within 30 days. That doesn't mean that something would have happened within 30 days, but they report back within 30 days. I have heard rumors also, and there are just rumors at this point, that there will be some sort of executive order. I've heard it might come down as soon as this week. Who knows? There were also orders, or also a lot of rumors about before the proclamation came in April, and it ended up, the proclamation is awful because it's preventing people from coming to the United States, but it wasn't quite as dire as people were thinking. Even immigration attorneys were saying he's stopping all of legal immigration, and that's just not true. Whatever happens, if there is an executive order, we'll get that information out to our clients as soon as possible. Of course, we would do another webinar to get people the information that they need. And then the other thing to keep in mind is that his power is limited. The Trump administration's power is limited. We do have a separation of powers in the United States. Of course, the administration has done more than maybe some people would argue they should have the ability to do. But anyway, putting that aside, if there is something that comes up, then I think there will be litigation, depending on the nature of what it is and how legal it's perceived to be. But I really think that there will be litigation surrounding it. So we will keep you all updated. Hopefully there's nothing. I do think probably something is coming, but we will keep everyone updated, and we are here to help all of our clients, past, present, and future, get through it together. We can do it. Thank you all so much for attending. Please share this information with your friends, invite them to join us next month, and hope you have a great rest of the day. Thank you so much.